Good afternoon, everyone, and welcome to our webinar on managing redundancies effectively during COVID-19. For those of you who don't know me, I'm Dan Fawcett. I'm a Managing Associate in the Southampton employment team here at Womble Bond Dickinson, albeit currently working remotely from home in Winchester. And I'm joined today by my colleague Lee Davis, who is a solicitor in our Bristol office. I've got extensive experience in advising clients on redundancy and restructure programs. Indeed, I qualified as a solicitor in 2008 during the previous recession, so a lot of the work I did very early in my career was very much advising on redundancies, and Lee's probably in a pretty similar position now as a junior member of our team. And additionally, recently on Clients Comment, I advised on a number of complex redundancies and restructuring programs, including being part of a HR team planning those right from the start. So hopefully we'll be able to give you some useful insights in today's session. Now, we anticipate that a substantial number of our clients and contacts will be seeing drop-offs in business and needs to reduce staffing numbers due to the recession generated by COVID-19. Some of you may well be able to manage any reductions in work through natural attrition or other solutions such as 4-day working weeks or reducing property costs through remote working. However, we believe that many businesses will need to be considering redundancies, and we therefore thought this was a really good time to provide a reminder of some of the basics of effecting fair and lawful redundancies, whilst also trying to provide you with some tips on the best approach in the current circumstances. And in that respect, I think we're very conscious that there will be some businesses that are very used to carrying out redundancies, and therefore I think the quirks of doing it in the current circumstances will be of most interest to them. Equally, there's probably quite a lot of people listening in who haven't had to do any redundancies for 5-6 years because business has been growing, and therefore hopefully the sections on the basics will also be really helpful. So lastly, before I start with the substantive talk itself, I'm just going to cover a few important housekeeping points. We are recording this session and we will distribute the recording after the event, but you'll all remain anonymous. We will not be referring to individual names or organisations if we answer questions so as to achieve that. Now, you may well have specific questions and burning issues that you want us to answer, and therefore want to know how you can ask those questions. There is a Q&A feature which should be visible in the right-hand panel on your WebEx, and you just need to expand that by simply clicking the right-hand arrow. At the bottom of the screen, you should then see a free text field where you can type a question. Once your question is ready, you just need to press enter to submit it. If the Q&A panel isn't visible, click the More Options button on the control panel, which has 3 white dots, and then that will re-enable it. Questions can be submitted throughout the seminar, and we will pick up some at the end, so don't worry if you think of a burning question after we've finished on the relevant topic. Now, just before we move on to the full talk itself, we thought we might use some polls to find out what those who are listening in are currently needing to consider within their businesses from the perspective of redundancies. But we've got 4 polls we'd like you to try and answer for us. First of all is that we would be interested to know how many of you are currently contemplating redundancies during the remainder of the year. For those who are, how many of you think you might need to carry out 20 or more redundancy dismissals? How many of those listening in have made use of the government's furlough scheme? And then for those who have, do you think the government's recently announced £1,000 retention bonus will make any difference to whether you need to proceed with redundancies. So I'll pause to give you a little bit of time to answer those poll questions. Looks like we've got, I think, most of the answers back in. So certainly 76% of those who are listening in look to be considering redundancies. Looks like about a quarter of those may need to be looking at redundancies of more than 20. And one of the first topics we plan on covering is collective consultation. So hopefully we'll be able to provide you with some useful guidance there. And looks like 74% of you think that the government's recently announced retention bonus is not going to make any difference to whether you need to proceed with redundancies. And I think that's very much in line with our thinking. I think it seems to us that that bonus will mostly be going to employers who would have retained the employees concerned anyway, and we're not convinced it's going to be particularly useful to employers. So helpful to know that I think most of you probably agree with us on that. So moving into the talk itself, I thought we would start by looking at collective consultation. We will then cover some of the key basics of effecting a fair redundancy dismissal, to then look at some common tricky areas that we know clients always struggle with in redundancy processes, and then to come on to hopefully provide some insights and guidance around doing this during COVID-19 and remote working and all of the challenges that poses. So starting with collective consultation, as you hopefully will all know, whenever you are considering dismissing 20 or more employees by reason of redundancy at one establishment, you have an obligation to consult collectively with employee representatives, be that a trade union, a standing body of employee representatives, or representatives who have been elected solely for the purposes of that process. Now, I think the place to start whenever you have redundancies coming up is always to make sure you know whether your collective consultation obligations will be triggered and whether you're under a legal obligation to carry it out, because that will inform a lot of the rest of your process. Another reason why this is really important is that if you get it wrong and you do not do collective consultation, but you were legally obliged to do so, a tribunal can make an award for up to 90 days pay for each employee you were proposing to dismiss as redundant. Therefore, failing to comply can be very expensive. It is very much to be avoided, particularly in the current circumstances where money is no doubt tight. Now, one thing just to cover in terms of the makeup of the definition of collective consultation and when you need to do it is what is counted as a redundancy dismissal for these purposes. So it covers not only dismissals that meet the statutory definition of a redundancy, so place of work closures and people you need to dismiss because work is reducing, but essentially any dismissal of an employee that is not directly linked to their performance or conduct or something unique to that employee. What that means is that if you have a redundancy program coming up, and then you might also be looking to change some employees' terms and conditions, perhaps to go down to 4-day-a-week working to manage reductions in work, then if you were going to need to follow a dismissal and re-engagement process for any employees who don't agree to that change in their terms and conditions, that would count as a redundancy dismissal for the purposes of working out whether your collective consultation obligations are triggered. So you would need to include not only the numbers for redundancies, but numbers for employees that you might need to dismiss for changing contracts type reasons when looking at whether or not you've got 20 dismissals within a 90-day period, meaning that you do have to consult collectively. Now, a particular challenge that we often see when advising large organizations is that very often business units operate in silos. They don't necessarily talk to each other and tell their other colleagues elsewhere in HR what redundancy dismissals they may have coming up. And that can mean that a legal obligation to collectively consult can be missed. Now, I've come across clients who introduce things like centralized trackers to try and keep an eye on this, and certainly in a large organization, if you think you might have lots of different programs coming up you need to keep an eye on, that's a really good idea. But it's important to explain why it is important for people to keep those trackers up to date. Otherwise, people will very much fall by the wayside and fall out of the habit of doing it, and you will end up in a position where you don't have reliable numbers and you can't assess whether you are under an obligation to commence collective consultation. Now, additionally, it's always worth bearing in mind that notwithstanding whether or not the legal obligation is triggered, you may have an agreement with your employee consultative body that says that you will always consult them on any redundancy dismissals, and if so, you should definitely make sure you do that because it will be part of your overall obligations to follow a fair process. The next thing to come on to is that I mentioned that the obligation to collectively consult applies where you are considering 20 or more redundancy dismissals at one establishment. Therefore, there's an important question about what an establishment means. Following a case brought against Woolworths after the previous recession, the law was in a bit of a state of flux, and the safest position for all employers was to, in fact, treat their entire organisation as an establishment for a period of time whilst we were waiting for the law to be clarified. So that essentially meant as long as you had 20 redundancy dismissals somewhere in your organisation, the safest thing to do was to assume you had to consult collectively. Now, luckily, when that case went up to the European Court, they found that our law did not fail to comply with some European legislation on this, and we are now back to the prior position, which is essentially that establishments will typically mean the geographic unit in which employees are based. So if you have got a multi-site business, your key question is, do you have 20 or more potential redundancy dismissals at any one geographical site, not is it 20 or more across the business as a whole. One word of caution, though, is do be very careful of field-based teams or home workers or anyone with slightly more unusual arrangements. It is certainly the case that you probably are not going to get away with arguing that everybody's home is an establishment and therefore you can dismiss 60 by way of redundancy without doing collective consultation if they're all home-based or field-based. I think the reality is you need to look at the management structure above them, and if they all report into someone based at a particular site, consider them to be part of that establishment. So organizational structure is relevant as well as geographical location. The next question that I think always vexes clients is when you actually have to start collective consultation. Now, all the law says is that you need to start it in good time. You'll probably all be familiar with some minimum periods of 30 or 45 days, depending on how many dismissals you're carrying out, and I'll come on to those in a moment. But the question is, well, what does in good time mean? Now, the reality is that what that really means is you should be starting your collective consultation process at an early enough stage that no final decisions have been taken, and therefore that your employee representatives will ideally have the ability to influence the structures that your business will move to have the ability to influence whether redundancies are required, or at least how many redundancies are required, and at the very least, even if that's not practical because there's been such a drop-off in business, it's clear that there will need to be redundancies, they need to be able to influence the process and to be able to contribute suggestions in relation to how you can mitigate the effects of redundancies or avoid the need for some of them. So really, as soon as you have a clear plan as to what redundancies you might be carrying out, you really do need to be starting your collective consultation before you've made any final decisions. The next question is how long you need to carry out the consultation process for. Now, again, you're probably all familiar with the fact that if you're carrying out between 20 and 99 dismissals, there's a statutory minimum period of 30 days, and that if it's 100 or more redundancy dismissals, that you'll know you're required to consult for at least 45 days. However, those periods are actually only relevant in terms of the time between starting consultation and when the first notice of dismissal takes effect. And that's the absolute cast iron thing you can't break down on. You cannot have anybody leave by reason of redundancy until either 30 days or 45 have gone by, apart from possibly volunteers if they do want to go earlier. However, in terms of the actual length of consultation with representatives, that's much more fluid. So in practice, if after 25 days you have covered everything you can possibly talk to representatives about, they have decided that they agree with your proposals and they're perfectly happy with your approach, you don't need to carry on having consultation meetings over the next 5 days until 30 have gone by. The only thing you can't do is dismiss anyone until 30 days have gone by. Additionally, it might be that in some cases you actually need to be consulting with representatives for more than 45 days because there is still something to be discussed. So it is one that you can kind of play by ear in terms of how the process actually pans out. The final piece that we wanted to perhaps spend a bit of time on collective consultation is your approach to employee representatives. So many of you will have a trade union. If so, it's perfectly straightforward that it's the union you will need to consult with in relation to any employees they are recognised in respect of. Alternatively, some of you may have a standing body of employee representatives. Now, if you do, you can consult with them, but you do need to be able to establish that when that body was set up, it was clear that one of their purposes was redundancy consultation. Additionally, it's helpful if elections or appointments to that body have taken place relatively recently so that you can genuinely argue that they are appropriate representatives for the employees affected by the redundancy proposal. If you have any doubt over whether the body's constitution actually does cover it dealing with redundancies, or you've had a lot of new joiners since you set up your employee representative body, it's probably better to elect a fresh set of representatives specifically for the purposes of your ongoing redundancy process. Now, this is one of those areas where I think COVID and remote working might cause some challenges, because whilst I don't have time to go into the detail of the election requirements in this talk, one of the key requirements is that insofar as reasonably practicable, you need to ensure that voting is done in secret and that votes can be accurately counted. Now, the easiest way of doing that is usually to have a ballot box in the corner of a room somewhere in your premises that employees can go to and put their votes in, but that's going to be tricky if everybody's working from home. So things you could think about, you can do postal ballots, but that might cause some time challenges if you really need to press ahead with redundancies quickly. It might therefore be worth looking at whether you've got IT facilities that would enable you to do anonymous staff surveys, and whether you could adapt something like that for this purpose. Sending votes in by email will not work because those votes are plainly not going to be secret. Two final points just wanted to touch on collective consultation. The first is just a real reminder that if your obligations are triggered, then you do need to file a HR1 form and send that off to the Government Insolvency Service. If you fail to do so, it is a criminal offence, so an important point not to miss. Finally, some of you may be concerned that whilst the statutory requirements are to consult for 30 or 45 days before any dismissals take effect, there is such an urgent need to make redundancies that actually you can't consult for that long. Now, there is a special circumstances defence you can rely on if you can show that it was not reasonably practicable to comply with the statutory minimum requirements. However, there are real challenges in relying on that defence at the best of times, and certainly I think in the current circumstances where you can make use of the furlough scheme, there are lots of government loans and grants available to businesses. I think it would be quite difficult to persuade an employer that you've really got special circumstances that mean you can't consult for that long. If for any reason you do feel the need to rely on that defence, the really important thing is to make sure that you still do as much consultation as is possible, and that will at least reduce the size of an award if you do end up with a protective award claim. So what I'm now going to do is hand over to Lee, who is going to talk you through some of the key basics of how to make sure you are dismissing for a fair redundancy reason and that you follow a fair and reasonable consultation process in getting to that point.
Great. Thanks, Dan. So as you'll no doubt be aware, redundancy is a potentially fair reason for dismissal. So before we launch into how to ensure that any redundancy dismissals are fair, we should identify in a little bit more detail exactly what a redundancy situation is. Now, Dan touched on this earlier. The Employment Rights Act sets out a specific statutory definition that many of you may be familiar with three sets of circumstances that constitute redundancy. So the first of these is where an employer stops carrying on business for the purposes of which an employee was employed. So in straightforward terms, this is full closure of a business or of a business unit. This includes temporary business closures. So redundancy is an option where a particular unit might not be currently viable, but you think that it might be something that you're able to resurrect again at some point in the future. The second of these instances is where an employer stops carrying on business at the place an employee was employed. So that's the closure of a particular workplace. And the third is where an employer has a reduced need for employees to carry out work of a particular kind. So that's a reduction of work requirements, which can either be at a particular site or overall across a number of sites. I mean, generally, it's quite straightforward to demonstrate that redundancy is the genuine reason for dismissals if you've decided to close down a business unit or a site. And this may be relevant for many COVID-related redundancies. But for place of work redundancies, the discussion is normally around mobility clauses. But at the moment, we'd say employers can probably expect that employees will propose remote working as an alternative. And employers will really need to demonstrate that they've considered it as an alternative just to ensure that any redundancies are fair. But the area that's challenged the most in practice is the reduction of work requirements. It's important to note that the focus here is a requirement not to cut costs, but on a reduced need for employees doing the type of work. And any business cases should be focused accordingly. And many employers do make the mistake of focusing solely on the requirement to cut costs, and that can result in flawed selection, but getting it right should be really straightforward in reality. You just need to look at why there's a need to cut costs. For example, if you're a manufacturer and you need to cut costs, it may be because you're receiving fewer orders from customers. It may be that there's a reduced need for staff on certain production lines, as quite a simple example. That said, as a general rule, tribunals are reluctant to interfere too much with an employer's view on whether a redundancy situation actually exists or why a particular employee's role is at risk. And they can't substitute their own view for that of an employer. They just have to assess whether the employer acted reasonably. Looking at unique roles, it may be that you've identified an individual in a unique role that you consider is no longer needed, or a pool of one. And in these circumstances, it's worth being aware that tribunals will pay more attention to this. Employers will need a robust business case if there is any argument from the employee that there are other similar roles. So it's just a word of warning, really. You can't simply presume that a role is unique just because it says so on paper. You need to compare the practical duties of that role to other roles which may be similar or an employee states are similar, just so that you can actually demonstrate that it's genuinely unique. Otherwise, there's a real risk there. Where any redundancies don't relate to unique roles, employers will be required to select from a pool. Say if you're reducing numbers in a team from 5 to 3. However, it's important to pay careful attention to who exactly should be in that pool to ensure that any resultant dismissal is fair. Again, here you need to look at the work that employees are practically doing on a day-to-day basis rather than job titles or descriptions that may be out of date, or in some cases that we've seen might not have ever been accurate in the first place. So to that end, employees who have similar skills and perform similar roles should probably be considered together. And as a general rule, if employees cover for each other during busy periods or any periods of absence, then there's a good chance that they should be considered as part of the same pool. And just a note to be careful on secondees. They should generally be considered as part of the team where the substantive role is based. This can lead to practical issues where it's not looked at properly. For example, secondees can be incorrectly included within a pool based on their secondment team or their secondment role, or vice versa. They may be incorrectly excluded from a pool by their substantive team, both of which are risks. Again, overall though, in identifying a pool, the employer only has to act reasonably, but it's just important to have a clear rationale which is documented contemporaneously, rather than having to come up with a rationale at the time of any challenge in a tribunal claim. I think from my perspective, and this really applies to the whole process, if you're coming up with rationale at the point of challenge, it would suggest to me that the initial process may have actually been flawed at some stage in the first place. And kind of a second, more practical point, if there's a risk of any future redundancies further down the line, it's not entirely beyond the realms of possibility that by the time of any tribunal claim relating to the first set of redundancies, those involved in making the initial decisions are actually themselves made redundant. And in these circumstances, the difficulties in obtaining witness evidence will just make the documentary evidence from the time all the more important. So having identified your pool, you need to carry out a fair selection exercise. Objective criteria should be used as far as possible. And for some roles, this is really easy. So where there are sales statistics or call volumes that can be used, for example. But otherwise, previous measurable appraisal scores, employees' skills and qualifications should almost always be appropriate criteria to use. Employers do end up often using slightly more subjective criteria. So, for example, adherence to corporate values. This will always carry a risk that any resultant dismissal is unfair. All that you can do is your best to mitigate these risks. Set out clear criteria with guidance as to how employees will be awarded marks. That makes the assessment as objective as possible. And frankly, any panels making decisions on that should ultimately ensure that any assessments are made in a uniform manner. Equally, at the same time, discriminatory selection criteria should be avoided. though in principle potentially discriminatory criteria such as length of service can be used, but with caution. This would need to be objectively justified. So, for example, in the instance of length of service, the legitimate aims might be maintaining a stable workforce or maintaining loyalty. Again, any justification should be considered at the time rather than when there's a challenge at tribunal. Generally, also, those criteria should not be relied on independently, because that really increases the likelihood that there'll be a finding of discrimination. Just a final point on selection criteria or not selection criteria. Historically, the public sector has relied on a recruitment type process rather than using selection criteria, so employees would be required to reapply for a reduced number of roles. This is often supported by unions, but real caution should be exercised here. There have been a couple of cases in the not too distant past. Gwynedd Council and Barrett, for example, which I think the judgment was delivered last month, found that requiring employees to apply for similar roles in a redundancy process was unfair, where the employees weren't given the right to make representations on the decision to dismiss, and there was no right of appeal. But a case heard last year actually upheld such an interview process. But that particular case involved a series of checks and balances, which included independent assessment by a 5-member interview panel, which helped to moderate the decisions made. So if you take this approach, you should review it and take real care, and probably really take legal advice on it. As a final point on carrying out fair redundancy, it's really important to undertake an individual consultation exercise. One of the key facets of a fair redundancy process is that an employee is given fair warning of being at risk of redundancy and is consulted with on a meaningful basis. It's therefore really important to ensure that relevant employees are clearly informed that they're at risk, and a series of meetings should be held to discuss the proposals and any counter proposals that employees may have. The meetings should explore any alternative employment opportunities, and ideally employees should also be given the opportunity to comment on selection criteria before they're applied. Equally, it's really important that employees are given their scores and consulted on them. Their responses and views should be listened to, and employers should consider whether or not anything should be changed. It's a step that's often missed. We've actually had a question in on this point, on how long the process should take. We'd say often 4 individual meetings over a 2-week period would probably be sufficient, but there are really no hard or fast rules on this. There is one instance where a tribunal upheld 7 days as long enough, but we really would not recommend that. That's absolutely fraught with risk, and I think almost in any case other than that one, it would have been found that the dismissals were unfair. A number of our clients like to consult for at least a month. You just have to bear in mind that some employees may require more consultation meetings than others, by way of reasonable adjustments, for example. But it's certainly fair to say that the earlier in the process that the consultation starts, the better. I will now hand over to Dan, who will discuss some of the more tricky issues that employers need to consider.
Excellent. Thanks, Lee. So I thought at this stage it was probably worth, just before we get onto some of the real sort of COVID-specific issues, just touching on some of the things that we get questions upon time and time again. And the first one of those areas, which always seems to me to cause a degree of confusion, is offers of alternative employment and suitable alternative employment, and the difference between the two. Now, in any redundancy process, employers are under a duty to help employees who are at risk of redundancy look for alternative employment opportunities. So you need to be making sure that you draw any vacancies to employees' attention. Additionally, in any circumstances where an employee accepts an offer, you have made them of an alternative role, as long as the role or its terms and conditions differ from the employee's existing role, the employee will be entitled to a 4-week statutory trial period in that role. And one of the areas that often seems to be missed is that sometimes employers think that they need to actually tell the employee about the trial period for it to exist, or they need to actually specifically offer it, but actually that trial period is an automatic legal right in any circumstances where someone accepts an alternative role. As a general rule, if the employee decides that the role is not working out at any point during that trial period and it's only an offer of alternative employment, then the employee is entitled to resign and they will still be treated as having been dismissed for redundancy for the purposes of a statutory redundancy payment. So they are still entitled to receive one. Where the question of whether a role is suitable alternative employment comes in is all about circumstances where you might want to withhold that statutory redundancy payment. So if you can establish that an offer you made to an employee or a role they took up was one of suitable alternative employment and they refuse the offer or they decide to leave during the 4-week trial period, then that is a circumstance in which you can withhold the statutory redundancy payment as long as you can establish that the employee has unreasonably refused the offer of suitable alternative employment. Now, in the current circumstances of COVID-19, it may well be that employees are less inclined to refuse offers because they will be quite keen to remain in employment. However, I can also envisage that a tribunal might take COVID-related factors into account when assessing whether an employee has acted reasonably in refusing an offer of suitable alternative employment. So, for example, in normal times, a new job in a location that's 20, 30 miles away from the employee's home might well be an offer that could actually be seen as reasonable, depending on how far the employee commutes at the moment or other factors. But during the current circumstances, if that was a vulnerable employee who will be putting themselves at risk by using public transport, I can see a tribunal taking the view that it was perfectly reasonable for them to refuse that offer at a different working location. Equally, if an employee currently does a job that they can perform safely from home and has no requirement to go into an office, and the offer of suitable alternative employment means they may need to go into their employer's premises, that might also be something that a tribunal would see as reasonable grounds for refusing an offer in the current world that we live in. Overall, it's almost always really high risk to decide that someone has unreasonably refused an offer of suitable alternative employment and decide not to pay them a statutory redundancy payment. And that's primarily because it's almost an invitation for them to want to bring a claim, and they'll probably throw in an unfair dismissal and a discrimination claim as well, whereas quite often if they got their statutory redundancy payment, they may well just happily move away and get on with some new employment somewhere else. The next point to pick up, I really won't dwell on, but I think at this point in time, understandably, employers will be quite focused on furloughed employees and some of the other difficulties that COVID presents. Really important to make sure you don't forget about the special rights that employees on maternity and other forms of family leave have to be offered any suitable alternative roles that do exist in preference to other affected employees, and also to be careful of any employees who are absent due to sickness, particularly if it's a disability. Try and make sure that there's no argument that the reason you've identified their role is in any way related to their absence. So those are just things to make sure you don't forget because you've got other things at the forefront of your mind. I finally just wanted to touch on voluntary redundancy. For businesses with a contractual or discretionary enhanced redundancy scheme, it can often be quite tempting to seek volunteers because if the amounts on offer are quite generous, you will often find that actually quite a lot of employees do just volunteer to go, and it makes your whole process a lot more straightforward because you can concentrate on consulting with those employees who do actually want to remain with the organisation, particularly where there are some alternative roles available that they might then be able to get. Now, it may be people are less likely to volunteer during COVID, but one other thing to be alive to is that if you just put an offer of seeking volunteers out with no conditions, a real risk is that you lose your best and your most experienced employees because they're usually the ones who get the best redundancy payment. So I think it's always important when seeking volunteers to make sure that you reserve the right to refuse any requests based upon business need. So that's just a few common tricky areas. We will now move on to picking up some of the COVID-specific challenges, and I think, Lee, you're going to take the first couple of these.
Yeah, thanks, Dan. So a fairly common question is whether or not employers can commence the consultation process whilst employees remain on furlough. We think this is quite a straightforward one. We think it's unlikely that attending consultation meetings will amount to work, and obviously those who have used furlough will know that employees, whilst for the time that they're furloughed, can't undertake any work for that employer. So we don't see that there's any reason this can't be done. That said, for employees who are on part-time furlough, it obviously makes sense to hold those meetings during time that they're at work. The second question, can we affect redundancies whilst the furlough scheme remains in place? In principle, we think the answer is yes. You may need a strong business case for this because employees are likely to argue that dismissing them whilst they're on furlough means that an employer has not made adequate use of alternatives. Some may even seek to argue that the employer should keep them on until January and make use of the retention bonus. An argument being, I suppose, that business could pick up at some point by then, so it's too soon to make redundancies. I'm not personally sure there's a huge amount in that, and it seems to me more persuasive that employers have to contribute to furlough from September, and that employees would also continue to accrue holiday entitlement at cost to the employer throughout this process. So you just have to make sure you've got sound business reasons for redundancies in those circumstances. From a timing perspective, it's also worth being conscious of the fact that the longer you leave any redundancy exercise, the more likely it is that employees could spill over into another year of service, resulting in higher statutory redundancy payments. So it's just something to be conscious of. I think Dan's going to pick up the next few questions.
I am, and I can see we've also had a question come in on the next one, which is the tricksy little issue of notice pay during furlough. Now, we think there is an answer on this, albeit it's not a particularly straightforward one. Now, I think what is clear is that if you were to make payments in lieu of notice, you can't claim those back under the furlough scheme, and that's because essentially the furlough scheme deals with monthly payments. So if you're paying out 3 months worth of notice in one go, for example, then that's not going to be something you can claim back. Now, the government's latest Treasury direction caused a lot of confusion about whether you could claim for furlough during an employee's notice period, because it said that the purpose of the scheme was about trying to keep employees in employment. Now, that's moved on a little bit because we now have some government guidance which at least makes it clear that you can continue claiming for furlough pay during a notice period. So the next question is, how do you actually calculate the notice due? Now, there are some very complex statutory provisions on notice pay generally, and the answer usually depends on whether an employee is entitled only to their statutory notice entitlement, i.e. 4 weeks if they've had 4 years service, 5 weeks if it's 5 years, or whether their contractual notice period is at least 1 week longer than their statutory notice period. And the current prevailing view seems to be that if you apply those provisions to the furlough situation, any employees who are only entitled to their statutory notice, or where their contractual notice is the same period, have to be paid in full, so on pre-furlough pay, during their notice period. If the contractual notice period is at least 1 week longer than the employee's statutory notice entitlement, then you can pay them at the reduced rate of furlough pay. Now, that's a good technical answer, but I think it probably creates some very unsatisfactory circumstances in practice where employers might be treating two groups of employees who are affected by the same proposal differently, depending on their contractual notice entitlement. So it may well be that many employers might decide in practice that they are going to pay everybody at full pay, but if money is tight, you can look at those employees who have a shorter statutory notice period than their contractual one and potentially pay it based on furlough pay. Now, one other point we wanted to touch on here is a question around how robust your business case needs to be in the current circumstances. Now, I think it would be very tempting to think that tribunals will obviously take the view that redundancies are necessary given that we're in a recession. However, the way unfair dismissal law works is that the approach an employer takes has to be reasonable in all of the circumstances. Now, at some point, some clever claimant lawyer is probably going to try arguing that reasonableness should be judged particularly harshly given the potential impacts of dismissing someone in a recession where there are going to be huge numbers of unemployed, and that an employer should think particularly carefully before doing so. So to counter against any arguments along those lines, we would suggest making sure you really clearly think about, and if necessary, discount all alternatives such as reduced working weeks or changing your property cost balance before deciding that redundancies are what you have to go with. Then wanted to pick up some of the real challenges with conducting processes remotely. So obviously at the current time, there are real challenges where a lot of employees and their managers will be remote from each other. Now, you certainly can carry out redundancy meetings remotely, although it is something that's always made me very nervous as an employment lawyer. I would always much rather people are in the same room. I think key points are, if you do need to do that, be really flexible with your approach. So make sure that you have as many breaks as possible. Try to use video conferencing rather than telephone calls, because I think given how much of communication is non-verbal, that gives each side a much better opportunity to get their points across. Make sure that you give employees and their representative breaks so they can confer, because otherwise that risks being missed. And try to make use of things like document screen sharing capability so you can take employees through documents properly. And also just think about Zoom fatigue. We hear a lot about how tiring it is for people to spend their whole day on video conferences. It may be that you need to schedule managers less meetings in one day than you would during a physical face-to-face process to try to accommodate that. One other thing I can definitely see arising is that I've advised on a number of cases where employees have particular mental health or neurological disabilities, which mean that they really struggle with maybe having anxiety about telephone calls or remote communication where they can't see someone face to face. If you have employees raising those types of issues, they may say it's a reasonable adjustment for you to actually invite them in and hold a meeting on a face-to-face basis. probably important to take medical advice if you've got the time to do it, but ultimately you can form an assessment as to whether it's reasonable to make a manager travel into an office to conduct a meeting if you think that might be putting them at risk, but probably worth making sure you get their view rather than making an assumption. I'll now hand over to Lee just to cover the final 2 points we had on our slides, and then we'll pick up some of the questions.
Thanks, Dan. So, yeah, how do you deal with redundancy where some staff are furloughed and some aren't? The main issue is ensuring that selection criteria are fairly applied. If a number of people have not been at work recently, then it's probably best to use pre-furlough measures in your selection criteria just to ensure fairness. And here, there may well be particular risks associated with employees in unique roles that have been furloughed. By way of comparable example, as employment lawyers, we often advise on processes where an employee is absent for a period of time, whether due to maternity leave, as touched on by Dan, or long-term sickness. And sometimes an employer concludes that, well, the absence has made little difference to my business, so there's no need for this role. In those circumstances, there's a substantial risk that redundancies are going to be discriminatory. There aren't any equivalent protections for people who have been furloughed, but disability discrimination is likely to be a risk if you've furloughed someone because they're vulnerable. Equally, if a tribunal is to conclude that an employee has been selected for redundancy for reasons related to being on furlough, there is a risk of an unfair dismissal finding there. It's just really important to have a robust business case actually explaining how the work done by those employees has reduced. And yeah, finally, with some specific COVID-related risk factors, it's a point I've kind of just touched on. It's just really important to ensure that vulnerable employees who have been absent because they're shielding, whether due to age or disability, aren't disadvantaged in any process that you undertake. You've just always got to be conscious of the discrimination risk. And it's also really important to be alive to any employees who might have made complaints about health and safety issues, or might claim that they've blown the whistle on some unsafe working practices around COVID. It can't form any part in an employer's decision-making process, and it would almost certainly be an unfair dismissal. So that brings us to the end of the substantive presentation. So we'll pick up some questions that have come in. So one question we've got is, what advice would you offer to HR if an employee refuses or fails to join a video conference or audio call that has been scheduled for a formal consultation meeting, especially if the consultation for the period for the individual or team is tightly managed? It should be dealt with in the normal way. You need to understand the reasons for the employee saying that they're not able to attend. If it relates to absence or a health condition, then you need to take OH advice, really. Otherwise, you'll probably be risking a discrimination claim. You may also need to consider any adjustments that are necessary to enable them to attend. Ultimately, the tribunal would want you to give an employee a reasonable opportunity to attend, but won't expect you to postpone forever. So if there's no reasonable explanation, then you need to send them a detailed letter just explaining the efforts you've made to get them to attend and seeking to rearrange. The letter should clearly set out the next steps that you're going to take in the event of a further failure to engage, just so that the employee is warned about that. Dan, do you want to pick up any of the questions that have come in?
So I think one of the other questions, and hopefully you can hear me, was how we support staff with mental well-being virtually if they're potentially at risk, and how you deal with circumstances where those staff feel isolated due to COVID. Now, I think there are a number of things that employers can do there. So first of all, if you've got an employee assistance program, make sure you draw that to your employees' attention and remind them to try to use it. Also, you can engage with your representatives and trade unions. So certainly worth having early conversations with them and letting them know that you think that your employees might require some additional support and sort of welfare support, and just ensure that they are thinking about how they can help you. You could also do things like encouraging affected employees to set up their own WhatsApp groups or to schedule support meetings using Teams or Zoom so they can check in with each other. Additionally, your employees' line managers might want to ask the employees whether they want them to check in with them. But I think each employee will have their own preference, and therefore it's really important that you check that's what the employee wants rather than doing something that they might view as being overbearing and just making assumptions. So always safe to make sure that you find out from the employee how much support they want, rather than just making your own assumptions on that. I think one of the other questions we had in advance was, do we have any tips for conducting meetings on employee online platforms, and in particular, how you might check whether an employee is recording the meeting, and indeed whether that's something you should actually care about. Now, some of that will come down to liaising with your IT teams. So, for example, if they can disable video recording features from the conferencing software you're using, at least that means the employee can't use the functionality that's within your system. Some of our clients have specific scripts that they go through at the start of a meeting, advising an employee they are not permitted to record a meeting and asking them if they are. Now, your employee might lie, but at least if you've asked an overt question and you then discover they've recorded it, that's dishonest, and you'll be able to treat it as a misconduct issue. Now, this may also be a factor in favour of choosing video conferencing over a telephone call, because then you can at least more easily see if your employee is distracted by someone else in the room, which might give you an indication there's someone else there. Now, all of that said, whether you actually care about an employee having someone present or recording the meeting may well depend upon your business. If you need to share a lot of confidential information whilst explaining a proposal, then you may not want there to be someone else sat in the room, for example. But actually, given the difficult circumstances in which you're going to be carrying out a redundancy process, if someone would really rather be accompanied by a family member in preference to a fellow employee or worker, I suspect most of the time it's probably best to agree to that anyway, and therefore this might not be a major issue. Now, we've got a couple of minutes left, so I'm just looking at a few of the questions we've had in, and one of those was, in fact, quite a few of those related to voluntary redundancy. So to just try and pick those up, a voluntary redundancy is definitely still a dismissal, and in that respect, it doesn't prevent an employee pursuing an unfair dismissal claim. Indeed, I think I had to defend unfair dismissal claims from employees who volunteered for redundancy. That said, I don't think you would offer a right to appeal. I think you can assume that if the employee has decided they want to go, then they want to go. I think we also had a question about whether if you decline a request, you can then put the employee through a competitive recruitment process for their role. Now, that comes back to the point that Lee picked up in his part of the talk earlier, that we would generally advise against competitive recruitment processes rather than a selection exercise, if at all possible. That said, if it's the approach you use, then certainly if an employee has volunteered and you've decided that for business reasons you need to decline that, they should go back into the same redundancy process as all the rest of your employees. They don't get taken out of that process just because they've been a volunteer. We did also have a question around apprentices and whether there are any differences for them. I think broadly the answer will be no, and that you can follow the same process you would with any employee, but there might be some slight quirks depending on the type of apprenticeship it is, and I'd probably need to look at those in a little bit more detail in order to properly advise on that. We have come up to 1 o'clock, so I think we should probably finish there and leave you all to go about the rest of your days. But it may well be that there are some questions that we can come back to people on individually. So I hope that's been useful to everybody, and we shall leave it there. So thank you all.
Thank you.